I keep telling them, first he says, first he says. Doesn't matter what the 50 is, or what the state of Minnesota is.
You did, I mean, you asked a question. I don't know about just ask a question, but you did ask a question.
All rise, please. Court's back in session.
Thank you. Be seated.
Your Honor, I'm so sorry. May I approach with the score sheet from this morning?
Okay.
Please? It was the case we had with Mr. Switek.
Yes.
Thank you.
We got some arraignments, is that right? What about Oliver Beck?
Good afternoon, Your Honor. Tim Gibbs on behalf of Oliver Beck. This is 23 CF 2452. Judge, Mr. Beck would like to enter a plea of not guilty if we could leave this set for pretrial 226.
Okay, he is charged with carrying concealed firearm, possession of less than 20 grams of marijuana, and possession of narcotics equipment, a felony and 2 misdemeanors.
That's right, Judge.
Okay. All right, Mr. Beck, February 26th is your pretrial, and get with Mr. Gibbs, get ready for your case, okay?
Yes, sir.
Thank you.
Thank you, Judge. Give me a call, make an appointment.
And James Burgess, 23 CF 2488.
Your Honor, Tim Gibbs on behalf of James Burgess. This is 23 CF 2488. Judge, Mr. Burgess would like to enter a plea of not guilty today, request 15 days for any pre-arraignment motions, demand trial by jury, and leave this set for pretrial February 26th.
All right, you're charged with trafficking in meth, resisting an officer with violence, battery on an officer, and vehicle theft. So, attorneys pledge you not guilty. We'll set you for February 26th, okay?
Thank you, Judge.
Thank you.
So we'll get all the discovery together and see.
Adriana Burgess.
Your Honor, Tim Gibbs on behalf of Ms. Burgess, 23 CF 2239. Ma'am, could you pronounce your first name for us for the record?
Elisaju.
Thank you. Judge, Ms. Burgess would like to plead not guilty and request 15 days for any pre-arraignment motions, demand trial by jury, and leave this set for February pretrial.
All right, you're charged with possession of a controlled substance without prescription and possession of narcotics equipment. Your attorney's pledged you not guilty. See you February 26th. Ted Grice, 23 CF 2486.
Your Honor, Tim Gibbs on behalf of Ted Grice. This is 23 CF 2486. Judge, we're entering a plea of not guilty, requesting 15 days for any pre-arraignment motions, and demanding trial by jury if we could leave this set for February 26th for pretrial.
Mr. Grice charged with possession of a weapon or ammunition by a convicted felon and a driving license suspended or revoked. Attorneys pledge you not guilty. See you February 26th. Thank you. Amanda Mattingly.
Judge Jay Williams for the defense. Ms. Mattingly doesn't answer the call of the court, Judge.
Same as for Capias.
No bond, Capias.
Yeah, I believe that's the only case I have on your docket this afternoon. May I be excused?
Sure.
Thank you.
Next case is Keith Simon. 23 CF 2441.
We've reached an agreement in this matter, if I may approach, Your Honor.
All right. This is State of Florida versus Keith Jonathan Simon Jr., 23 CF 2441. All right, Mr. Simon, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, sir.
Okay. You want to enter a no contest plea to the charge of driving license suspended, a third-degree felony, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You wear the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to time served. $415 court cost, $100 cost of prosecution, $150 PD fee.
Your Honor, there was a shotgun that was seized at the time of his arrest. Now that he's going to be a convicted felon, he won't be able to obtain it back from the sheriff's office. So he's asking that his father be allowed to, that the sheriff's office release it to his father. The state had indicated they had no.
I don't have an objection, Your Honor. If the sheriff's office will do their own vetting, because if his father for some reason can't possess firearms, they won't. But I have no objection to returning it to whoever the defendant waives it over to.
And
that's
if you
fine.
could say his name for the
Keith
record.
Barry Simon.
Keith Simon?
Yeah,
Keith Barry Simon.
if it's, if the state has no objection to it, then I don't. Okay, so, okay.
Okay.
And I'll need to talk to you before you leave, sir.
Christopher Watson. All right, this is 23 CF 2450, Christopher Watson.
That's correct, Your Honor. He's charged with unlawful sexual activity with a minor and use of a two-way communication device to facilitate a felony. He's going to enter a not guilty plea, request trial by jury. We'd ask for the 2/26/24 docket. If we can get this worked out before then, we'll put him on earlier
All
docket.
right, February 26th, sir, thank you.
Mhm.
All right, what we got next?
Your Honor, there is the one case, it was the Stillions case, it was just a status, which I mentioned to the court that the attorney was on standby, and the court said could handle that by phone. Whenever you're ready.
Okay, give me that name again.
The case name is Stillions. And I believe it is going to be your second one on your afternoon docket.
Oh, okay. Maryland Stillions?
Yes, sir.
And I'm calling who?
It's going to be Jake Rollman, and I have that written down for the court if you wish.
Okay.
May I bring that up?
He represents Miss Stillions?
Yes, there is the Jake Rollman, and there's the phone number, yeah, indicating you reached out. Madam Clerk, this is the one that
Hello, this is Attorney Jake Coleman.
Mr. Groveman, this is Judge Gonterick. I'm calling you from the court room in a courthouse in Crestview, Florida, on the case of Maryland Stillions, and that is 2017 CF 2520. And I have Ms. Basso with the State Attorney's Office here representing the state. So we're having a status conference on Ms. Stillions. Go ahead, Ms. Basso.
Your Honor, in speaking with Mr. Rollman, it's the defense's intent to proceed with the 3850 motion. The state is ready to proceed, and I believe we're asking the court for the next available afternoon docket for that. Is that correct, Mr. Rollman?
That is.
Well,
It would need to be after the first of the year, I believe, Your Honor, because there's going to be transportation.
about February 8th.
That works for the state, Mr. Rollman. Would that work for you, or do you wish something possibly sooner, or?
Is there anything sooner, Your Honor? Just out of curiosity, anything maybe on January 24th, the 29th, the 30th?
Do we have court on January 25th? We have a big docket on that.
There's only 3 separate
How about January 25th?
Yeah, I can do that, Judge. Absolutely. Thank you.
How long is this hearing gonna take approximately?
Mr. Rollman, sir?
Ms. Mostow, if you have any suggestions on length, I don't think we've discussed it previously unless there was something in the emails where we mentioned it.
It's going to be primarily your questioning, sir, and your witnesses. I would say we probably want to plan on an hour and a half to 2.
I agree. Maybe we'll just docket it for 3 hours out of an abundance of caution, Your Honor.
All right, what else do we have, Ms. Anna?
Except for that day. We have 2 sentencing. It's the one with Mr. Mosley.
Oh, it's another 30 minutes. That one will be about 2 hours.
Maybe the 25th isn't going to work then, Your Honor.
What do we have, February 27th?
February 8th, we'll put that up.
How about the 8th? I think
There's nothing on the
okay. How about February 8th?
I have something tentative that week, Your Honor, that's not confirmed, and I'm just trying to keep some things off of that week, especially an all-day or a 2-day trip up there. That was why that week was difficult, but I do want to get this set.
Mr. Rollman, did you wish to maybe grab that while it's still open, and then if you need to approach the court?
Let's
instead
do
of
that.
waiting with you?
That's a good idea.
Okay, February 8th, right? Okay, we'll set it for that, and we'll see what we can do.
And it's going to be afternoon, Your Honor?
Yes. Typically starts
thank
at
you.
1:30. Okay?
My office is happy to file a notice of hearing, Your Honor, unless your judicial assistant does that.
No, you can do it.
Will do, Your Honor. Thank you.
Okay, thank you. Anything further?
I'm from the defense, Your Honor.
Where are you located?
I'm down in Bradenton, Florida, right on the border of Bradenton and Sarasota.
Okay. All right, thank you. Look forward to seeing you. Thank you.
Likewise, Your Honor, and thank you for allowing me to appear on the phone today.
No problem. Thank you. Bye.
Bye-bye.
Thank you, Judge Johnson.
All
Let's
right.
do that. Do you want me to take the note or do you?
Yeah.
Thought it in that paper up here.
Your Honor, if we may briefly readdress Keith Simon, who got the license suspended.
Yeah.
I was speaking with the state. He had spoken, I guess, with the sheriff's office. They had indicated they would need, as long as they got a court order to release the gun to the dad, that they would be fine with that, but they would want an order from the court. So I spoke with the state. She just asked me to run it by her, if that's okay with you, that we could submit that.
Yeah, but put in there that he is, let's
Has
see.
to be legally eligible to,
Well, and I suddenly forgot, what was your name again?
Mr. Simon.
He is not to have contact with it.
Right.
Okay, because that, that's going to be a felony if
Yes,
you,
sir.
so put that in there.
Okay.
Okay. All right, thank you, sir.
Thank you.
Who else we got here that we need to do?
Who this is that just walked in? I've got Mr. Kilburn lined up. Kilburn?
All right, Daniel Kilburn.
Yes, sir. Page 4 of your docket. Charles
Pardon?
Russell, Public Defender's Office. Judge, this is Daniel Kilburn. Case numbers are 17 CF 3565 and 21 CF 452. We're here on the state's motion for child hearsay and Williams rule, and I think the state has some announcements.
All right.
Your Honor, as to the 173565, the Williams rule motion that we have filed, the state's going to withdraw that at this time.
Okay.
We do still have the child hearsay motion in place. Your Honor, we did have a suggestion in speaking with the court. It is a lengthy child hearsay interview. The state's intent would not be, even if it's granted, to play the entire thing, so the suggestion was made that myself and Mr. Russell agree possibly to an edited version and then present that to the court, understanding that the defense will be arguing against it and the state will be arguing for it. But then that way, it'll be just what the state would intend to present as evidence, and it wouldn't be the entire
So
trial.
Mr. Russell would have a chance to look at the entire video and then perhaps agree to an edited version.
Yes, Your Honor, and the entire version has already been provided to the defense, just to be clear for the record.
All right.
And just a couple things for the record, Judge. If they're going to withdraw their Williams rule, I anticipate before trial that the state is going to renew their Williams rule request. We would ask that it be done sufficiently far in advance of the trial schedule that we can have a hearing and have it taken care of before we get to the actual trial dates. And then on the child hearsay, I doubt there's anything on the CPT interview that I will want in. So if the state will send me an edited copy, I'll look at it and, then I can just let the court know this is our position. And we would ask that the court set maybe the cases for a status conference between now and 2/26 so that we can just kind of see where we are.
That would work for the state, Your Honor, if the court's inclined to do so.
And Judge, you said Mr. Lett's case for 12/27. Is 12/27 too soon?
It would be too soon, I believe. I'm sorry if I need to get you the edited version. I'm gonna need some help.
January 4th.
January 4th?
I can do my very best I just need to get the edited version of Mr. Russell. That's gonna be the long pole in the tent. I need someone else to actually do the edits.
What about January 25th?
That definitely will work.
Try that. We'll do that one.
At 9, Judge?
And if I get it to Mr. Russell sooner and he's ready, then we can always just move it up.
Okay.
Thank you, Your Honor.
All right,
Thank you,
thank
Mr.
you.
Russell.
Thank you. Thank you, Judge.
Judge, I believe that's Mr. Scarborough that just walked in. I think Mr. Notes continued his case earlier today, but I'm not certain exactly why or when. I know it was addressed earlier this morning.
Who is, come on up, Mr. Scarborough. Who is with, who's,
Oh, I'm sorry, Mr. Scarborough. I'm sorry, Your Honor. He's mine, and he was Mr. Nopes's. Mr. Nopes indicated this morning that he would need a little bit more time to speak to Mr. Scarborough and his family, and the state was not objecting to that.
Okay, what date was he set for?
February 8th at 9.
February 8th. Your attorney was here.
Okay.
But he couldn't come this afternoon, so
Okay.
he handled it for you.
Yes,
He
sir,
wants to-
absolutely.
He'll get with you.
Yes,
or
sir.
get with him, February 8th,
Thank you.
okay?
Yes, sir.
Thank you,
And
sir.
Your Honor, if I may briefly for the record, just for Mr. Scarborough, sir, there was an offer provided to your attorney, and we indicated that it would be open until the 8th.
Okay. Thank you.
Thank you.
All right.
Thank you, Your Honor.
Thank y'all.
I'm just showing Akins and Sanders. Who do we want to have first?
We can do the plea first.
All right.
Akins.
So I'm not in English.
We'll get Akins.
Just the same meeting. He comes to see us start to talk.
I believe that's all I had. Your Honor, may I be excused?
Wait, what did you say?
May I be excused?
Oh, okay. I thought you said you had a bond hearing. I was like, bond? I don't understand.
Are you going?
Okay.
Am I going? I want to watch this and then I come there like before the hearing.
Okay, this is Johnny Lee Akins, 2021 CF 2155.
Yes, Your Honor. For the record, Jennifer Flowers with the Office of Regional Conflict on behalf of Johnny Lee Akins Jr. and 21 CF 2155. Your Honor, today Mr. Akins is prepared to enter a no contest plea as charged in the information to count one. It will be an open plea to the bench and set for sentencing at a later date. And Your Honor, the state is going to announce a null pros on counts 2 and 3. We have reduced it to writing, even though it's not a agreed upon sentence, just to make it clear. On count 1, there will be a minimum mandatory 25-year sentence. And Mr. Akins understands that, but I have the plea agreement that we have signed.
Okay.
That I can approach.
And for the record, that is the state's agreement, Your Honor.
All right, this is State of Florida versus Johnny Lee Akins Jr., 21 CF 2155. You are Johnny Lee Akins Jr.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God?
Yes, sir.
Thank you. You want to enter a no contest plea to the charge of second-degree murder with a weapon which carries a maximum sentence of life in prison with a minimum mandatory 25 years, correct?
Yes, sir.
And the state is going to dismiss count 2, tampering with evidence and possession of firearm by convicted felon upon entry of the plea.
That is correct, Your Honor.
All right, Mr. Akins, did you read and sign this plea and sentencing agreement form?
Yes, sir.
Did you understand the rights you're waiving by entering this plea?
Yes, sir.
Did you thoroughly discuss your rights and everything mentioned on this form with your attorney, Ms. Flowers?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Has she answered all your questions and discussed the possible sentence with you?
Yes, sir.
You understand you're looking at a minimum mandatory 25 years in prison with credit for time served?
Yes, sir.
Is there any DNA evidence that would help out the defendant that has not been provided to the defendant or his attorney?
The
Any
state is
exculpatory DNA evidence?
The state is unaware of any exculpatory evidence, Your Honor.
Is there a factual stipulation?
Defense stipulates.
The arrest report or offense report is the factual basis, Your Honor.
All right, the court finds the plea is, do you have any questions about this plea, Mr. Akins?
No, sir.
And you understand there's no agreed-upon sentence, that apparently you're leaving it up to the discretion of the court? Court finds the plea is freely and voluntarily entered. Court accepts it. The state is going to announce a null pros on count 2 and 3.
That's correct, Your Honor.
Okay. I'll order a pre-sentence investigation and put off, I want to have a chance to thoroughly review. You'll have a chance to have input on the pre-sentence investigation and make any type of statements you wish to as to what you think the sentence should be. And that will be, we will have that. When do you feel like you want to?
We had discussed possibly February 8th.
I believe February 8th I'll be in a judge trial.
Okay.
I'm not sure the BSI could get, well,
Okay.
why don't we put it
Your Honor, if
for
you can give us some more time, we'd appreciate it.
February, how about February 26th? Is that too soon?
That is a pretrial conference date.
That's too much on that?
I would ask for a date, like a miscellaneous afternoon.
About February 8th, is that a busy day?
That's a day that I'll be in a judge trial and on the south end.
We have court on February 29th? We got cases set on the 29th?
Probably not yet.
I mean, is that a real date, February 29th? I thought,
I was just about to ask, Your Honor, is that a real date next year?
yeah. Okay, February 29th. We'll try for that day, okay? How much time has Mr. Akins served already?
He's been incarcerated since his arrest in 2021 at the Okaloosa County Jail.
2021? Okay. All right. All right, sir. Thank you. And, you know, I'll listen to what everyone has to say and make a decision on February 29th.
And I would anticipate an hour and a half to 2 hours for the sentencing hearing.
Okay.
There'll be witnesses and.
Yeah, I got you. Okay, thank you, sir. Thank you.
Mr. Sanders?
Deion Sanders.
Yes, Your Honor. For the record, Jennifer Flowers with the Office of Regional Conflict on behalf of Deion Sanders. We're here today for a sentencing in case number 17 CF 1389, 19 CF 358. Those are VOPs. 21 CF 1105 and 21 CF 683, for which Mr. Sanders has previously entered a plea as charged to the court on October 26, 2023. Your Honor, I have a packet for the court and the state.
For the record, Your Honor, this case law has been previously provided to the state. The state does not intend to bring up his manslaughter charges.
Your Honor, the packet
Okay.
includes case law that I have previously
Yeah.
provided to the court. And on the first page, or the first part is the plea agreement, a copy of an unsigned plea agreement just so the court, it's part of the record on benchmark, but just so the court has a copy, as well as the score sheet that's previously been provided to the court. If I may
Alright.
approach.
Yes.
Your Honor, this defense is not calling, has no witnesses for the purposes of this hearing. I don't believe the state does either, so it'll be.
You're not calling witnesses, is that what you said?
No, Your Honor, I just have argument.
Okay.
When the court's ready, I can proceed.
You've already provided me these cases, if I'm
Yes,
not-
Your Honor.
Yes, okay.
I just wanted to
remember that,
provide them
yes.
to you today, and
Well, I saw they were already provided to me. I looked at.
Yes, I just went ahead and printed them, so you have a copy.
Okay, oh, I got you.
Yes,
All
Your
right.
Honor.
Okay.
So today, like I said, we're here on a sentencing on these cases that he's previously entered a no contest plea and admission to the VOPs, previously on October 26, 2023. There's 2 VOPs, like I said, 2 new law offenses. The first, 21 CF 683, count 1, third-degree felony, fleeing or attempting to elude, and 2 misdemeanors, and 21 CF 1105, count 1 is a trafficking in phenethylamines, which I've also provided the court and the state with just a printout to specify what those were, so there wasn't any confusion that this is not a fentanyl case, this is a phenethylamines trafficking case that carries a 3-year minimum mandatory on count 1. Counts 2 through 4 are possession charges, and count 5 is a resisting misdemeanor. The score sheet has also been provided to the court for review previously. The defense has also filed reciprocal discovery, 9 letters from the defendant's family, friends, and members of the community for the court's consideration. I presume the court has had a chance to review those. The state, and Your Honor, the state indicated that they're not going to be bringing up the pending charge against Mr. Sanders. However, I feel it necessary to address on the record because on 11/16/23, the state filed an amended discovery exhibit with the court and submitted 4 letters composed by the victim's family in the pending case of 21 CF 1943, for which the defendant has neither entered a plea and maintains a plea of not guilty in that case and is expected to go to trial in that case. The case is pending before the court currently. He's made no omissions other than the fact that he was arrested in that case number. The court has heard no evidence, and the defendant has not entered any no contest or guilty plea. And the defense, for the record, would object to the state's assertion that the court consider any allegations made in case number 21 CF 1943 for purposes of sentencing in today's hearing, and most certainly objects to specifically letters written by a victim's family in a case in which the defendant has neither been convicted or entered any plea. I've provided the case of Norville versus State, which is a Supreme Court case in Florida, in which the Supreme Court established a bright line rule that a trial court may not consider a subsequent arrest without conviction during sentencing for the primary offense. This rule is consistent with the Criminal Punishment Code and preserves the defendant's due process rights during sentencing. I've also provided the court and state copies of the following case law: Barron v. State, Brown v. State, and Williams v. State that stand for that same assertion. Briefly, to summarize the court's findings in Barron v. State, the court shall not consider a new substantive crime in a separate case that is still pending at the time of sentencing, and the court's consideration of a new charge, a pending charge, is constituted as reversible error. In Brown versus State, the 5th District cites Norville.
Let me stop you right
Yes.
there. Are y'all going to be arguing that?
No, Your Honor.
I mean, I think that law is clear what Ms. Flowers is saying, so
The
I'm
state-
not going to consider what he's charged with subsequent to this.
Yes, Your Honor. I felt it
Okay.
necessary to address, and I won't go into further detail on the
All right,
cases
well,
since I provided
I
them.
agree- I agree with you.
But since the state did submit letters from the victim's family for the court's consideration, I just want to make sure that it's
I
clear on
didn't
the
see
record.
'em.
Okay.
I mean, if y'all want me to look, I don't think I should look at them, because it
Yes,
has
Your
nothing
Honor.
to do with this, as far
Yes,
as
Your
I'm
Honor.
concerned.
Yes, I just wanted to make that clear, and I'll move on. What the court shall consider are the charges before it that the defendant has admitted and pleaded no contest to, as well as his prior convictions, which are all reflected on the score sheet provided to the court. I want to point out and go through his priors. There are no allegations or prior charges for any violence, and there's no sale of drugs in his prior history. He has 2 prior possession felony charges, 5 prior misdemeanor possessions of marijuana, 1 introduction of contraband charge, which the case had to do with the contraband introduced was marijuana, 1 failure to appear, and 2 misdemeanors for no insurance or registration. Do you have your statement? And at this time, I believe Mr. Sanders would like to read the court a statement that he has prepared. This will be an unsworn statement, not subject to cross. He's just prepared a statement for the court's consideration.
Okay.
I would just like to say I'll take full responsibility for all my actions as a man. I know my poor decisions, it ain't take it on me, took it on my kids and my family and everybody in the community. These last 32 months, I took all the time that I can do to grow as a man and do everything I need to do with myself. And I ask that you give me a fair sentence. I take care of all my kids, my 2 daughters and my 3 stepdaughters. I'm a big leader in the community. I try to have good intentions on everything that I do, and I'm not making no excuses for anything that I did, Your Honor. I'm manning up to that, and I just pray that you give me a fair chance to get back to my family. That's all I ask. That's all I got.
Thank you, Mr. Sanders. In addition, we'd like the court to consider that I previously referred to the content of the letters submitted as reciprocal discovery. A letter from Anthony Shepard, an owner of a business, One Up Cleaning, and cousin of Mr. Sanders, who promises in his letter a job for the defendant when he is released. A letter from Kaish Sanders, defendant's little brother, Audrey Sanders, his stepmother, Justin Miller, his stepbrother, Katie Sanders, his grandmother, Jasmine Reynolds, his cousin, Joanne Reynolds, his aunt and sister of his mother who passed away in 2007, Kaylin Sanders, his younger sister, and Eddie Sanders, his father, who was an Air Force veteran and deacon in training at New Bethlehem Baptist Church in Birmingham, Alabama. I think those letters speak for themselves, and if the court has reviewed them, they show how much that Mr. Sanders is adored and admired by his family, how much he means to not only his family, but to the community at large, that he is a leader, that he is a pillar in the community, and that he is greatly missed. Mr. Sanders' mother died of breast cancer when he was just 13 years old. He has undeniably faced hardships in his young life. He is 30 years old. He turned 30 this May 25th of this year. He has also undeniably made mistakes and bad decisions. But Mr. Sanders is a father. He has 2 daughters, Isabella and Nieta, and 3 stepdaughters that he cares for as well. They age between 9 years old and 14 years old. The letters make it clear that he loves his daughters and wants to have the opportunity to be the father that he knows he can be, and that his family and friends and community knows he can be the father that his daughters deserve. We also ask the court to consider the fact that Mr. Sanders is here today because he has admitted and taken responsibility for his mistakes. He has expressed remorse for his actions. He has taken responsibility for the mistakes that led us here today. We respectfully ask the court to consider Mr. Sanders' genuine remorse and the fact that he pled openly to these offenses in making its sentencing decision. We also want to point out that his prior record, which reflects no violence and no prior sale charges, Mr. Sanders dealt with an addiction issue, not a sale issue. We also want to point out that the legislature has established the guideline score sheet and the point system for a reason. Mr. Sanders, the defendant's guideline score reflects an appropriate sentence as established by the Florida legislature. Taking all this into consideration, we are asking the court to sentence Mr. Sanders in accordance with the guidelines of the score sheet, which are 69.975 months Department of Corrections with credit for time served, to include the required statutory 3-year minimum mandatory sentence on count 1 in 21 CF 1105. The state has alleged, or I'm not aware that the state has alleged any aggravating factors to justify an upward deviation from the guidelines, other than a new pending charge that is not before the court today. that the defendant, as I said, intends to go to trial on. The case law establishes should not be considered in sentencing. The state is asking the court to sentence the defendant severely above the guidelines based on a pending charge for which he has neither been convicted or pled to. Their intentions are clear based on the fact that the state has made 0 offers that did not include a plea also to case number 21 CF 1943, and the fact that they submitted 4 letters referencing that case, which is not before the court today. Other than that pending charge, I'm not aware of any aggregating factor that should be considered by the court in today's sentencing. Therefore, as I said again, we're respectfully asking the court to impose the sentence reflected on the score sheet, which is 69.975 months DOC. Thank you. May we sit?
Yes.
Sit for their states.
Your Honor, Michelle Sandler for the state of Florida.
Okay.
Deion Sanders is a drug dealer. He was trafficking in phenylethylamines. It was tested by the DEA. It was 67 grams of Udalone. Udalone is bath salts. Bath salts are the substance that was commonly known around Florida that came around where the guy chewed the other guy's face off. That's Udalone. And 67 grams is a trafficking amount. It's a trafficking amount because that is not personal use. And that's not something someone would have an addiction problem with. That's something someone is selling. As far as aggravating factors go, Mr. Sanders is here on 17 CF 1389 for fleeing or attempting to elude law enforcement with lights and sirens. That's a second-degree felony that carries a 15-year penalty. Also has a misdemeanor of resisting without violence. He's here on 19 CF 358, 4 counts of possession of controlled substance, which was a reduction from trafficking. He has been arrested for trafficking before. Fleeing or attempting to elude, driving while license suspended, and resisting without violence. He's here on 21 CF 683 for another fleeing or attempting to elude, driving while license suspended or revoked, and resisting without violence. And he's here on 21 CF 1105 for trafficking in phenylethylamines, possession of controlled substance, possession of controlled substance, possession of controlled substance, and resisting officer without violence. He is a drug trafficker who is dangerous to the community. He's been given breaks by the state before, and that's why the state didn't make him an offer. The defense opened the door to talking about this, so we're going to talk about this. We're not going to talk about the facts, but we're going to talk about the fact that the state made a global offer because he had so many cases, which is very common for the state to do in order to have a global resolution. It's also common for the state to say, we're done with someone at a particular point in time, and to not offer them any more breaks. Mr. Sanders has gotten the benefit back in 2017 and in 2019. He's not getting the benefit from the state anymore, and that's why we made no offer. In 2019 CF 358, he was originally charged with trafficking in hydrocodone, 3 counts of sale, manufacture, deliver, and another fleeing and eluding. This was the first break he was given by the state, and he pleaded to 4 counts of possession of controlled substance, fleeing and eluding, driving while license suspended or revoked, and resisting without violence. He did not last on community supervision. In March of 2021, he picked up another fleeing and eluding. This is now a pattern of running from the police. He was going over 100 miles per hour, and the break that he got in this case is that we didn't amend the information to a second-degree felony, which would have given him 15 years of exposure instead of 5. With all the breaks he caught, though, Judge, he's still selling drugs. Shortly after that arrest in March and May of 2021, he was arrested for trafficking in oxycodone, trafficking in cocaine, possession of controlled substance, possession of marijuana, and resisting without violence. That was sent to the DEA and found to be Udalone, which is a synthetic stimulant, also known as a designer drug, It's a dangerous designer drug, and it's commonly mixed with other drugs. This is not a fentanyl case, but this is a designer drug case, where this Udalone is being sold as God knows what. The defense brought up that Mr. Sanders is a family man. We've got all these letters from his family. Everybody he's sold drugs to has a family too. And no one's family member wants them to go to prison, but the law is the court can't consider that as a reason for doing a downward departure. Everyone has a family. And as the defense brought up, these aren't Mr. Sanders' only charges. He's been doing this since 2011. He started with misdemeanor marijuana and worked his way up. 2011, 2012, 2013, 2014, 2015, 2016, 2017, 2019, 2 cases in 2021, and he's been in jail since. The reason we haven't seen him again is because he's been incarcerated. The state is asking the court not to show Mr. Sanders mercy or leniency at this point. The state asks that the court sentence Mr. Sanders in accord with the same respect he's shown the public, with his consistent dangerous behavior and drug dealing activity. He has not obeyed community supervision, and he has absolutely no respect for the law or community. If he were to get out after a 3-year minimum mandatory, which is almost the amount of time he's been in, he would go right back to dealing drugs, because he would essentially be released immediately. Nothing has helped Mr. Sanders so far. Nothing is teaching him a lesson. And the purpose of sentencing in adult court is punishment, not rehabilitation. There's been no evidence presented that he has a drug problem. And there's no rehabilitation at play here. He's not an addict that needs help. He is a drug trafficker. Right now, his total exposure on just these charges is 90 years. That's his total exposure on just the felony charges. If the court were to find that the drug trafficking enhancement applies as it is the primary offense on the score sheet and multiply his score by 1.5, he would score 115 months, not 69.9 months. He's pleaded to a first-degree felony. His exposure is 30 years just on that alone. The benefit of his plea straight up to him is the limitation of his exposure, but it does not mean that the state believes that the guidelines are appropriate, sufficient, or commensurate with his criminal behavior. First, he keeps fleeing and eluding from law enforcement, driving without a license at high speeds, and this makes him a danger to the community. Second, he keeps dealing drugs, which is even more dangerous to the community. There is nothing about his behavior so far to believe that he is going to stop this activity if the court sentences him to guidelines. He should receive a sentence commensurate with his behavior and his disrespect for the law. He should receive an adjudication of guilt and 15 years on 2017 CF 1389 with a concurrent 5 years on each felony offense and 19 CF 358, a concurrent 5 years in 21 CF 683, and 30 years in 2021 CF 1105 on count 1 with a concurrent 5 years on each possession count and 1129 with credit for time served on all his misdemeanor counts. That is half of his maximum exposure. It's commensurate with his disrespect for the orders of the court, this community, and the law. Thank you, Your Honor.
Well, how much time has he served on all these put together? In county jail, and how much credit has he got?
32 months, Your Honor, roughly. Your Honor, may I make a brief rebuttal statement?
Okay.
Your Honor, I just wanted to point out a couple of things. First, the state referencing that he is a drug trafficker and that he's a drug dealer. There are no facts before the court other than the trafficking charge is a charge based on the weight of a certain substance that is in possession of a person. There's no element that...
Your Honor, I'm going to object at this point. He's already pled to drug trafficking. This would be arguing the facts that he's not guilty of drug trafficking at this point.
Your Honor, I'm not arguing... Sorry. Thank you. I'm not arguing that he's not pleading to drug trafficking. I'm arguing against the state's categorizing him as a drug dealer and a drug seller when there are no facts before the court. He has no prior drug sale charges, and the trafficking, yes, he's pled no contest to a trafficking charge, but I'm just pointing out, as the court knows, that is a charge that has no elements that require proof of sale or intent to sell. This is not a sale, manufacture, deliver case. This is I'm just pointing out that the trafficking is based on a weight that is assumed to be...
I understand.
Yes, Your Honor. Also, I wanted to point out that the state referenced that my argument was that he was in need of rehabilitation and that we were asking for a downward, that's not a reason for a downward departure. But we're not, I just want to make clear that the defense isn't asking for a downward departure. The defense is asking for the court to impose the guideline sentence as found appropriate by the legislature, and that there is no asking for a downward departure in this case. That Mr. Sanders has taken the responsibility and is asking for not a downward departure, but to do the time that is appropriate pursuant to the legislature and the guideline sentence.
What was the state asking for again? Because you...
The state was asking for 15 years on 2017 CF 1389, with a concurrent 5 years on each felony offense in 19 CF 358. So that would be concurrent. A concurrent 5 years in 21 CF 683, and 30 years in 21 CF 1105 on count 1, with a concurrent 5 years on each possession count. And the state would have no objection if all of that was to run concurrently.
Mr. Sanders, you have a family that apparently thinks highly of you and loves you, but I'm wondering if you think highly and love them, constantly getting in trouble, into drugs, and you're going to end up getting yourself killed or someone else killed. And you know, the life expectancy of people that use drugs is not very long. Court does give weight to you admitting your guilt or taking responsibility. I didn't see any firearms in any of this that I could find. Was there any firearm allegations?
No, Your Honor.
No, Your Honor, and no prior convictions or arrests even that I'm aware of that deal with firearms. And no violence in his prior record or alleged before the court today.
All right, on count in 17 CF 1389, count 1, or in that case, I'm going to give him 80 months. With credit for time served. In 19 CF 358, 60 months on each of the felonies concurrent with each other, and 1389. If there's any misdemeanors in that, 11 months, 29 days in county jail. In 21 CF 683, 60 months concurrent with 11 months, 29 days, and any misdemeanors in that case, and concurrent with the other cases. And in 21 CF 1105, 80 months, Department of Corrections, minimum mandatory 3 years, credit for time served concurrent with 1 year or 11 months, 29 days on any of the misdemeanors. All the misdemeanors are going to get 11 months, 29 days in all cases, all counts. The felonies are all going to run concurrent. And it looks like 80 months on the on the 21 CF 1105, it's 80 months concurrent with the 80 months in the 17 CF 1389.
Yes, Your
So
Honor.
it looks like the maximum he's doing is 80 months, credit for time served, minimum 3 years. So you've served how many? About 3 years. So with gain time, you probably be out a lot sooner than 30 years.
Thank you.
I ain't got it figured out yet, but probably do another 36 months or something like that, or I'm not quite sure, but because I didn't see any firearms in this, Mr. Sanders, and you took responsibility, I'm giving you the lower end of the guidelines. The drugs is just a dead-end street, you know that. So you got potential for a job, I think someone was saying, so get some training down in prison and some courses or something, and get out and get with your family and start a new path, okay?
Yes,
All right, thank you.
Judge, will it be 60 months on count 2, 3, and 4 of 1105 as well?
Yes. The 80 months is the maximum. Okay?
Thank you, Your Honor.
Here's your,
And that concludes my business with the court. May I be excused, Your Honor? Thank you.
Is that everything? There's your way to push back right when you walk by me.
all right, was there any, Miss
I believe that's all.
Miss Dudley, you
I
got?
don't have anything, Your Honor.
You don't?
No. Just observing.
You just came back to watch this great judicial skill up here?
Yes, sir.
Thank you, Judge. Have a good evening.
That's what it was.
All right, I think that's it, right?
Yes,
Judge, I think so.
Just Grace. Judge.